Now I would like to move to Professor Uprimny, and from the very outset, I would like to say that this is a particular day for me, because I am welcoming him not only as an outstanding constitutional lawyer, a human rights lawyer, but also as my friend. And this is just great to see you, Rodrigo, here. Professor Uprimny is a Colombian lawyer, studied law in economy at the universities in Paris I and Paris II, and then made his PhD at the University of Amiens, Picardy. Currently he is professor of constitutional law, human rights, and theory of the state at the Universidad Nacional in Bogota. He is founding member of the Center for Study of Law, Justice and Society, De Justicia, and executive director of this organization, which is part of the civil society in Colombia, a very powerful, influential organization. And in the framework of this organization, also Professor Uprimny participated in the peace efforts in this during this difficult period of his country, the period of internal conflict. He used to be Deputy Justice of Colombian Constitutional Court. He's member of the UN Committee on Economic, Social, Cultural Rights, as Dean said. But I wanted to point here out that within the committee is not only very much appreciated as a highly knowledgeable, very experienced specialist in the area of human rights, but also he is a chairperson of a working group on communications. This is a sort of internal arrangement in the committee, but I have to say two words about it, because it's really, in order to understand the importance of this function of this group, I need to explain it. Some years ago, in fact 6 years ago, the optional protocol to the Covenant on Economic, Social, and Cultural Rights entered into force, and then a very remarkable process of making economic, social, cultural rights at the international level, at the UN level precisely, justiciable. This process started. Since 2013, the working group and the committee received more than 200 complaints, because the word communication is I have to explain to those who don't know it. This is an example of something which is really beloved in the United Nations, and this is using euphemisms, because in fact we are talking about complaints, but since governments are usually uncomfortable with this very concept that somebody can lodge complaints against them, they agreed that they can use the word communication. So we are saying communication, but in fact what is the subject of this procedure are complaints. And this process started. We have received, as I said, more than 200 complaints. And in fact, each decision of the committee, which is prepared by the working groups, establishes precedences in the interpretation and application of the standards of economic, social, cultural rights. Leading this working group, Professor Uprimny has enormous, I would say, impact, but in particular, he makes an enormous contribution to the development of this procedure. And I really would I have to share it with you. Recently, I finished an article where I was trying to present also what the committee is doing in this respect. And I must tell you, Rodrigo, that I was surprised what we have already done under this umbrella of this complaints procedure, and it was mainly thanks to you and your wisdom, your knowledge, your qualifications as an outstanding lawyer. These are extremely interesting decisions of the committee. The committee is not a judicial body, it's quasi-judicial body, but the decisions look like really like judgments of courts. And I can only encourage all of you to look at this for the time being still moderate legacy, but it's already building I would say, a new dimension of the doctrine of economic, social, cultural rights. Professor Uprimny was a visited scholar at the American University, as we had in University of Grenoble and other universities. I will not list them, all of them. He's a human rights advocate, lawyer, and researcher in human rights at the Colombian section of the Commission of International Commission of Jurists, and he was also a consultant on the various international national projects. He published a number of, I don't want to mention the number of the articles, books, and parts of monographs. All of them are largely dedicated to the issue of the rule of law, of the constitutional state, of democracy, but also of the social relationships in terms of law. He also was awarded with several distinguished medals and awards, inter alia National Award for Simon Bolivar in journalism, Special Award of the National University for Academic Excellence twice. So in order to still keep the presentation short, I have to just to put an end to my introduction, and I would like now to ask Professor Uprimny to present his lecture. After the lecture, we will have the opportunity to not only to pose questions to our guest, but also to share our views. In particular, I would like to invite those who disagree with the lecturer, because this makes usually the meetings more interesting. Professor Uprimny, may I invite you?
Good afternoon to everyone. First, I want to thank the organizers for the invitation to this lecture, especially my very good friend and colleague at the Committee on Economic, Social, and Cultural Rights, Professor Ketsia. It's really an honor and a pleasure being here for sharing with you some thoughts about the Colombian peace process, if you want, in a comparative perspective. Before entering directly into the subject, I would like to make 3 caveats. First, as Zizek said, this is a subject for me is quite emotional. I'm being strongly involved in the discussion about this peace process, and I think that we have achieved a very decent agreement with the guerrilla to get out from an armed conflict that has caused millions of victims in Colombia with honor and with justice for victims. So I've been strongly supportive of this peace process, but there are many people who are very critical. So I want to say that because I will try to be the most objective I can, but I recognize that I can have some biases in favor of this peace process. The second is that if you have ever read the recent news about Colombia, you will know that this peace process is in risk of collapsing. The current government, which was elected 6 months ago, is led by a president who is not a fanatic of this peace process. He is against this peace process, and he is not implementing it really. At this precise moment that I'm speaking here, the president is presenting a veto against a very important piece of law for implementing the peace accord. But I don't want to focus on the current situation, because I think that for you is better to have a general overview, a more structural overview of the armed conflict in Colombia and the peace process. At the end, or if you have some questions, I can come back to the current situation, but I will not deal exactly with that. And third, Colombia is, as you will see, is a quite complicated country, and our armed conflict has been quite complicated. Our peace process is quite complex. Of course, I cannot, in a lecture of 1 hour, try to deal with all aspects of the peace process. So I will try to focus on two things that I think are might be very interesting for scholars in law, and these are the following ones. The first is the issue of how to combine the effort to find justice for victims with the effort of achieving a political settlement of an armed conflict. That is the so-called tension between justice and peace that in Colombia we call the issue of transitional justice. And the second is what is the relationship between a peace process and the constitution? Does the peace process need a new constitution? Can you do it within the framework of a constitution? Do you need special procedures? And I think that is also a very important aspect for legal scholars. These are the two subjects in which I will focus. But of course, you will need some background about Colombia, because I know that you are not experts in Colombia, and so you need a background. So with that, you can understand the structure of my presentation. I will begin in first part to provide you with a background about Colombia. I will speak about Colombian democracy, the armed conflict, our peace process. That is a general background. And then in the second part, I will enter in these two very complex aspects, that is transitional justice and the relationship between constitution and peace process. And these are the parts of my presentation. So let's begin with the context. And the context is that Colombia is, if you want, a very paradoxical country, a very complex country. Why? Because on one side, if you look at Colombia, it looks like a very strong democracy, a very long-standing democracy. Colombia has been an independent country for about 200 years, and we have had very few coups d'etat, very few years of open dictatorship or military rule. I would say less than 10 years in 200 years. That's a record for Latin America, but I would say even for Europe, a country that have during 2 centuries a renovation of power essentially through elections. So it seems a very stable and powerful, and if you want, powerful democracy that have resisted very difficult challenges. A democracy that dealt with an armed conflict, a democracy that was attacked by guerrilla, by paramilitaries, and also a democracy that has to deal with the issue of drug trafficking and mafias. Maybe you don't know very much about Colombia, but of course you know about Pablo Escobar, and you have seen Narcos in Netflix. So you know a little about Colombia. And we have a quite strong rule of law in Colombia. We have a quite clear separation of powers, and Colombia has been respectful of the independence of the judiciary, much more strongly even than many European countries. Let me put you just one example. In 2010, the then president of Colombia, Álvaro Uribe Vélez, which was a right-wing president, a very authoritarian president, but immensely popular. His rate of approval at that time was about 80%. And he wanted to change the constitution in order to make a third term. He has already managed to change the constitution to obtain a second term. And he wanted to change it again to obtain a third term. Everybody, most people in Colombia agree with that. but the Constitutional Court said to the president, that's too much. We accepted that you change the Constitution once, but twice you are going to destroy the separation of powers, you are going to destroy medular principles of the rule of law, which is alternance, so we don't allow you to change the Constitution, even by referendum, to have a third term. And this very authoritarian president accepted that. And then he was not re-elected. And we have the election of a new president that was Juan Manuel Santos, who won the Peace Nobel because of this peace process. So that shows, if you want, a kind of very strong democracy. However, on the other hand, if you look at Colombia, you see another picture, a very different picture. And this other picture is a country in which you have very deep shortcomings of democracy. It's a country that have lived for about 50 years, a protracted armed conflict that, as I said before, have caused millions of victims. We are speaking about 6 or 7 million of internally displaced persons within a country of 45 million. That's 15% of the population. We are speaking about more than 75,000 enforced disappearances. So it's a country that has lived a very deep humanitarian crisis for the last 5 or 6 decades. At the same time, it's a country with very strong social inequalities. I don't know if you know the notion of the Gini coefficient that says that when you have one, it's a society that is absolutely unequal, and if you have 0, it's a society that is absolutely equal. More than 0.35, it's already a very unequal society, and Colombia has about 0.58 in relation to the Gini coefficient, which is one of the highest in the world. So if you see this other picture, you say, no, that's not the democracy that you were painting to me. Here you have a country in which life is not respected, there is a strong inequality, the state cannot control the whole territory, and you have armed actors. And that's what makes the complexity of the Colombian situation. It's not by chance that Gabriel Garcia Marquez was born in Colombia, the great writer, because when he writes these things that seems marvelous, he's just describing the complexity of the Colombian society. So how to characterize this very complex political regime? So some people say that Colombia is a kind of democracy in danger, a democratic state that have faced very strong dangers and have resisted them. But others say, no way, Colombia is not a democracy in danger. Colombia is more a dangerous democracy. That is a democracy in which you cannot live safe. With a colleague, in order to try to solve this conflict of interpretation, we say that Colombia is a dangerous democracy in danger. And it's not a boutade. It's to show that Colombia is both things, that this legalistic Colombia, this democratic Colombia is strongly linked with this terrible Colombia linked with the armed conflict. And that's the very complex Colombia that was trying to solve its armed conflict. So we have a complex country. But as we Colombians lack complexity, we couldn't have a very complex political system without having at the same time a very complex armed conflict. It would be too easy. So the armed conflict in Colombia have been quite complex. It's not, if you want, an easy armed conflict in which you have the state combating an insurgency. Let's think about, the Cuban Revolution. Then you have the dictatorship of Batista fighting the guerrillas of Castro. So a very easy to distinguish conflict. No, in Colombia, we have several actors, several drivers, and several moments. So let me explain that very succinctly. First, we have several actors. We have had several leftist guerrilla groups, at least 4 large guerrilla groups. The FARC, the most well-known internationally, but we have also the ELN, the National Liberation Army, who is still fighting. We used to have the M19, a leftist but more nationalist, not Marxist guerrilla, and the EPL, the Popular Liberation Army. So these were very different groups that sometimes cooperating among them that were born in the 60s and 70s and were trying to defeat the Colombian government because they said it is a very restricted democracy, a very unequal country, and so we need to go to power in order to achieve either a social revolution or at least a very strong economic redistribution. So they were born, if you want, as classical guerrillas during the Cold War. Then you have the second actor, which is the Colombian army and the Colombian political armed forces. But it was not enough. Then we have also the paramilitary groups, the right-wing paramilitary groups. These were born in the 70s, 60s, but 70s, and mainly in the 80s and afterwards. And these were right-wing armed groups that at one moment they were created by the army after they were born autonomously, but they have a lot of collusion with the armed forces, and they attack if you want, the social support of the guerrilla by committing massacres, enforced disappearances, etc. But as it wasn't enough, we not only have these 3 actors, finally we have the narcos, that is the criminal gangs that operate like regional mafias, and they have very complex relationships among them. So we have a complex armed conflict. But secondly, this armed conflict is also complex because the drivers of this armed conflict have been changing without a total change, but have been evolving. At the beginning, in the 60s, 70s, and I would say even the beginning of the 80s of the last century, it was, if you want, a classical Cold War guerrilla insurgency. That is leftist guerrilla combating a capitalist state supported by the USA. That was, if you want, the panorama. But with the drug trafficking that began at the end of the 70s and the beginning of the 80s in Colombia, you have another driver, that you have illicit economies. And this illicit economies has fueled the armed conflict and has also transformed the actors. So in that sense, Colombia is a mixture of a classical Cold War, civil war, or armed conflict, combined with what certain authors like Maria Caldor call the new wars, wars that are not connected to ideological reason, but control of resources and controlling illicit economies to try to obtain money. Colombia is the mixture of both. The guerrilla are still political actors, but they have been strongly involved in drug trafficking, kidnapping, etc. And these illicit economies have given them a lot of military and economic strength. So that's the complex Colombia political system, the complex armed conflict. And of course, if you have a complex political system and a complex armed conflict, you wouldn't expect to have a very simple peace process. You will have, of course, again, a very complex peace process. And then, to finish the context, I will enter in this complexity of the peace process. The peace process in Colombia is complex because we have had several waves of peace processes. The peace process that began in 2012 and ended with the 2016 peace accord between the government and the FARC, which is what is known by the international community, was one of the last effort of several efforts of trying to make peace through political means in Colombia. The efforts of peace process began in the 80s. So that's why several scholars said that Colombia is at the same time a country of permanent war and permanent peace efforts. We have made, from time to time, efforts to end the armed conflict through military means by the state, but also through political negotiations. As I said, the first efforts were in the 80s. They failed miserably, and then you have an increase in the war, and you have an increase in the existence of these paramilitary groups that were created by the army, landowners, and more drug traffickers. And then at the end of the 80s and at the beginnings of the 90s, we have a partial successful peace process. With this partial successful peace process, two of the guerrilla groups demobilized. The M19, which was this nationalist leftist guerrilla group that demobilized, and the Maoist group, the EPL, the Popular Liberation Army. They demobilized, and this peace process didn't provoke, but was linked to a process of democratization of Colombian society that ended in the Constitution of 1991, the current constitution in which we have been living. It's a very democratic constitution that enshrines all human rights, including economic, social, and cultural rights, that open political participation, that try to create a kind of very multicultural and multilinguistic society. So it's a very open, a very democratic constitution that has been implemented in several aspects by the Constitutional Court that Zizek was speaking about. And so after that, after this opening that was created by the negotiations in the 90s that were conducive to the 1991 Constitution, the reinforcements of the rule of law, in spite of that, the armed conflict increased in the 90s and until the end of the 90s with the remaining guerrillas, that is the FARC and the ELN. So there was another attempt of making a peace process at the end of the 90s, but this, especially with the FARC, but this attempt collapsed. And because of this collapse, this enormous failure of this attempt at the end of the 90s, in 2002 was elected President Álvaro Uribe with a very strong support for a military solution for the armed conflict. The Colombian society was saying, with the FARC and with the ELN, it's impossible to find a political settlement. We need now a military push. At that moment, the guerrillas were very strong. They were controlling part of Colombian territory. So from 2002 until 2010, with the strong support of the United States, if you know, that was the so-called Plan Colombia, in which the United States provided Colombia with military support, but also with financial support. At the beginning, it was stated like an anti-narcotic program, but it became more and more a counter-insurgency program. So President Uribe, or during the President Uribe, there was a strong push to defeat the guerrillas, especially the FARC. The push was especially against the FARC, that at that moment were very strong. And at the same time, President Uribe made a kind of negotiation. I said a kind of negotiation because it was a very obscure negotiation, on the contrary of the negotiation of President Santos with the FARC that I think were quite transparent. This negotiation was made by President Uribe with the paramilitary groups, the right-wing paramilitary groups. In the sense, the paramilitary groups thought, as President Uribe was a right-wing politician and rise to the power, they don't need to remain attacking the guerrilla, so they could demobilize. And there was a partial demobilization of the paramilitary groups. So that was the context between 2002 and 2010. A strong push against the guerrilla by President Uribe. He was quite successful in giving the guerrilla strong military defeats. After President Uribe, I would say the guerrilla were strategically defeated. This has important benefits for Colombian society. Security in the cities increased, and in some rural areas, the rate of homicide diminished. But at the same time, it have enormous human rights costs because of the authoritarian way these military attacks were made. I'm not against that. In 2002, the Colombian state had to military face the guerrilla, but I'm very strongly against the way it was made by President Uribe because it was conducive to a lot of extrajudicial killings. We are speaking about 3,000, 4,000 extrajudicial killings made by the army, and with a lot of internally displaced persons. We are speaking about 3-4 million of internally displaced persons in this period. So it was an effective strategy, but a very costly in human rights perspective strategy that I think was unnecessary. But the Colombian society supported President Uribe in these efforts. And then we arrived to 2010. As I said, there was this ruling of the Constitutional Court that said, no, President Uribe, no way. We defend the rule of law, and with the defense of the rule of law, you cannot change the Constitution every time you want to be reelected. The Constitution exists to constrain the political powers, not that the political powers can use it to perpetuate in power. And so his Ministry of Defense, President Juan Manuel Santos, was selected. And to the surprise of everyone, President Santos changed the policy. He didn't say, we have to keep trying to defeat until the end the guerrilla. In a certain sense, we have defeated them strategically, but we have to make a peace process to end quickly this armed conflict that have taken 5 decades to diminish the humanitarian cost, and that could even strengthen democracy. And he launched it against a lot of opposition, a peace process with the FARC. And this process that was launched in 2012 succeeded in 2016 with the peace accord. So before entering in the 2 subjects that I want to stress, transitional justice and constitutional change, one last remark about why, in this case, the peace process with the FARC succeeded, whereas in the past, at least in 4 times, it was a failure. It's not easy to explain, but I would say that there were at least 4 factors that have a strong influence in that. The first one was, of course, that the guerrilla, the military strength of the guerrilla was diminished, thanks to the military offensive made by the state during President Uribe's 2 terms. That's, and I put in brackets, that's why I never understood why President Uribe is against this peace ex-President Uribe is against this peace process, because he could say this peace process was possible thanks to the military action made during my government. But he didn't assume this position. He was strongly against the peace process. But I think that was a factor. The guerrilla at that moment, I think they knew that they were not defeated in tactical terms, but that it was going to be very difficult. I would say they knew that it was impossible that they would defeat the Colombian state at that stage, that have strengthened its military force and the state apparatus. The second element is that we have a very positive international panorama. We have President Obama in the United States, who was in favor of the peace process, and we have several leftist governments in Latin America that were in favor of the peace process, like Cuba, Venezuela, that at that moment wasn't suffering the crisis that it's suffering at that moment, Ecuador, Brazil, they all supported the peace process in Colombia. So everyone was in favor of the peace process. We didn't have international spoilers. And finally, the third reason is that President Santos was able to establish a very good peace team, a very good peace negotiators that knew about the previous failures and structured very well the negotiations. And with that, I enter into the negotiation itself. Why the negotiations were very well structured? And I would say because there is this saying by a very good scholar that used to say that injustice creates wars, and at the same time, injustice creates civil wars, and at the same time, civil war created injustices. The notion is, if you have something like an armed conflict, usually there is an injustice at the origin, but the existence of the civil war or the armed conflict at the same time created new injustices because it created victims. That was Jan Elster who said this proposition. So if you want to make a good peace process, you have to address the injustice that were at the root of the armed conflict, but you have also to address the injustice created by the armed conflict. And if you see the peace process in Colombia, I think that they managed to do both things without entering that the peace process was going to solve everything. That was one of the mistakes in the past. One of the mistakes in the past was a peace process that wanted to solve all Colombia shortcomings. And that, of course, it's impossible. But others wanted only a peace process in which the guerrilla demobilized. The Santos government created a middle ground to address the root causes of the armed conflict, to address the problem of victims, but without entering in the whole spectrum of Colombian society shortcomings. And so they established a peace accord in which they would reach, they would reach one problem that was at the root of the armed conflict with the FARC, that was rural reform, the inequality in the rural area that was crucial for the FARC. Second, problems of political participation, to widen political participation, because in Colombia there were restrictions in political participation that I don't know if they created the armed conflict, but that at least they were invoked by the guerrillas as a reason for rebellion. And finally, to address the problems of the drug economy, of the drug trafficking, in order to have a more clever policy vis-a-vis drug trafficking. And with that, they deal with the root factors at the origin of the armed conflict and the driver that intensified the armed conflict, that was the drug trafficking. But they decided also to deal, for the first time in the Colombian history, and I would say for the first time in comparative perspective, to deal with the issue of the victims. That is, to try to achieve a peace process in which the issue of victims was dealt with, that the right of victims were incorporated. And with that, I enter into the second part of my presentation, which is these two very complex aspects. That means that I will not enter into the issue of rural reform, drug trafficking, or political participation. These are complex issues, very complex, but I cannot deal with that. I will deal only with the issue of victims and the issue of the relationship between the peace process and constitutional transformation. So with the issue of victims, the first thing, it was a very contentious issue in Colombia, a very difficult issue. Let me put it one practical example. The other issues that were already very complex, rural reform, political participation, drug trafficking, each one took 6 months in the table of negotiation to be solved. The issue of victims took 2 years. That shows how contentious the issue was. So I'm going to summarize in 10 minutes 2 years of negotiations. So you can understand that I'm going to be very schematic, but I think I can give you the main elements of controversy and how they were solved. First, what was the problem? Or what is the problem? And you can imagine what's the problem. The problem is, if you want to have a negotiation with an armed conflict, then you have to provide, to accept for this armed conflict, the possibility of entering into politics. That's the main issue of an armed conflict, that a political actor that is in rebellion transform in a political actor that go through democratic means. That's the essence of a peace process with a political actor. But for that, you cannot put in jail the leaders or the members of this armed actor for 60 years or something like that. They have committed heinous crimes like massive kidnapping, extrajudicial killings, murdering of peasants. So the FARC have committed heinous crimes. So if you apply to them the ordinary justice, then they would have to go to jail for 60 years or something like that, and peace process was impossible. So the former way to do that was to provide everyone with a general amnesty. That was the traditional way of making peace until 15 years ago. But now this way is impossible. It's impossible, I would say even it's unethical, because if you do that, then you will ignore the suffering and the claims of victims that said, we need justice, we need truth, we need reparations. So the problem is how to balance both claims that go, at least in short term, in contradictory directions. Either you make justice and then you don't achieve peace, or you make peace with amnesty and you don't achieve justice. How to balance that? That's the discussion, and it's a very difficult, very difficult discussion. How it was solved? And I would say that's not the way it was dealt, but I try to if you want to put in a schematic way what was very complex in practice. And I would say it was achieved thanks to 5 mechanisms. The first mechanism was to open the discussion of who were responsible. A lot of people said, we are negotiating with the FARC, so the only thing is to establish the responsibilities of the FARC. But many people said, okay, but those responsible of heinous crimes in Colombia are not only the FARC. They have committed heinous crimes. But what about the paramilitary groups? What about the army that have committed 4,000 extrajudicial killings? We are going to leave that in impunity, or we are going to deal with that at the same time. And for the FARC, that was crucial, because they said, we are not going to make peace without being defeating in military terms, only to be defeated in judicial terms. So the first thing was to open and to say, okay, any mechanism that we are going to establish is not going to be against the FARC only, but it's going to be to arrive for a legal closure of the armed conflict, of all the responsibles in the armed conflict, including third parties. Third parties would mean those members of the economic elite that might have contributed, for instance, to paramilitary groups in certain parts of the country. So that was the first one of the decisions that was made. It was a decision that was strongly contested by certain sectors that were against the peace process. And I think that's one of the main reasons why they were against the peace process, because they feared that the responsibility might be established through this mechanism of transitional justice. The second way to deal with that was not only to widen the possible responsibles, but to widen the spectrum of mechanisms. Usually the issue of justice is understood only as the issue of criminal justice, that you have responsibles, like Nuremberg. You have those responsible of the atrocity of the Second World War. They go to Nuremberg and they're punished, and that's it. But if you make that, then it becomes a more complex game for negotiation. Whereas, because first, a lot of victims would say, okay, you have established the criminal responsibility of some actors, but what about my life? What about the truth? Am I going to receive reparation or not? So the second decision that helps to widen the protection of rights of victims, but at the same time to widen the discussion was to say, no, transitional justice is not only about criminal justice. Transitional justice is, as Pablo de Grave, the former special rapporteur on these issues of the United Nations, used to say, should have a holistic approach in which all the rights of the victims are incorporated. Not only the right to justice, but also the right to truth, the right to reparations, and the guarantees of non-recurrence. So with this second idea, it was established that any mechanism of transitional justice wouldn't be only a mechanism of criminal justice, but of establishing an integral mechanism for providing the satisfaction of the rights of victims. And that included a truth commission. Second, a strengthening of the program of reparation that already existed in Colombia, but they said that they would strengthen these mechanisms of providing material, collective, individual, and symbolic reparation of victims. Third, humanitarian mechanisms. For instance, it was established a mechanism for trying to establish the truth about those who were disappeared during the armed conflict, try to find the remains in order to allow the families to find a closure for this terrible tragedy, which is the enforced disappearances, in which, or even the disappearances in which you don't know what happened with your beloved, and you cannot then find a closure. So to establish a very practical mechanism to try to solve the truth about that and maybe find the remains of these persons. And finally, the issue of criminal justice. With that, then the issue of criminal justice is only one part of a mechanism. And so that allows to have a broader discussion. We are dealing with the right of victims, but in a broader form. And so in that way, the FARC felt that they were contributing to satisfy the right of the victims. And then we enter the three more contentious things, which has to do with criminal responsibility. The first is who was going to judge. Before that, there was another very important issue that was, okay, the FARC, after a lot of discussion, accepted that heinous crimes should not receive amnesty. But at least, for them that was very important, they should receive amnesty for their rebellion, for the very fact of taking arms against the Colombian state. And that was accepted. That was accepted, that was within the Colombian tradition, that those who rebel, as long as they have political objectives, and as long as they do not commit heinous crimes, they can obtain amnesty for what we call that political crimes and crimes connected with these political crimes. And that was accepted, to give a broad amnesty for political crimes, including connected crimes, as long as these crimes were not war crimes or crimes against humanity. These were excluded from amnesty. That was very important because it simplified the procedure, but also it was a kind of recognition that the armed conflict has political motivations, that it was not only a criminal gang that was attacking the Colombian state, but it was a political actor with which the Colombian state was, or the Colombian government was negotiating. And so that was accepted. Here we have a strong controversy in relation with drug trafficking. Could drug trafficking be a connected crime with rebellion that could receive amnesty or not? And many Colombians thought that not, because they was thinking about Pablo Escobar, and they were thinking to give amnesty for drug trafficking would imply to have given amnesty to Pablo Escobar, and that's unacceptable. But I think that that was a wrong perspective. The perspective was, if a person used drug trafficking to make a political rebellion, then drug trafficking could be subject to amnesty, but not the heinous crimes committed by drug traffickers. That's a different thing. But that was very controversial in Colombia. At the end, they said that drug trafficking in connection with the rebellion could be subject to amnesty. The fourth thing was an institutional one. And the fourth thing, the institutional one, is who is going to be the institution that is going to judge this person for the other crimes. You have the political crimes, and in connection with that, they should receive amnesty. But what about the other crimes, the heinous crimes, the war crimes, the enforced disappearances, the extrajudicial killings, the massive kidnapping? What about that? Who is going to judge them? And here you have a very, very strong controversy, a very, very strong controversy. On one side, the FARC said, you have not defeated us, so we are not going to surrender to your judicial system, because that would mean a surrender. And for guerrilleros, this notion of dignity and not surrendering is crucial. And they said, no way, we are not going to surrender to your judicial system. So we need an international tribunal. And the Colombian state said, no, okay, we have a state that has difficulties, but that's not the state that has collapsed. We have our own judicial system. We are not going to accept an international tribunal, and the Colombian society is not going to accept an international tribunal. What to do? Then it seems a zero-sum game in which it was very difficult to find a solution, but I think that a very creative solution was designed, and the solution was to establish a new jurisdiction that was essentially a national jurisdiction. And so in that way, the position of the Colombian state was accepted, but this jurisdiction was born from the peace deal. So in that sense, it was not a surrender to the justice of the enemy, as the FARC thought, but that all actors in the armed conflict accepted that a new jurisdiction that was born from the armed conflict would judge the atrocities committed by all actors. And that was we call the HEP, because of the acronyms in Spanish, the Special Jurisdiction of Peace, which is a very complex institution that I cannot detail. So that was the fourth element of this design. And then we have a very controversial fifth element. The very controversial fifth element was, okay, but what about the sanctions? Okay, if you provide truth, because that was accepted, this special jurisdiction is going to work in a similar way that the South African case, but it couldn't be equal to the South African case. If you remember, in the South African case, those who provided truth of the crimes committed with political motivation received amnesty. If they didn't provide all the truth, then they could be investigated by the judicial system. But this solution was not available anymore, because that would mean impunity, and that would mean the intervention of the International Criminal Court, and that would mean that a lot of people in Colombian society wouldn't accept this solution. So what about, they have to receive a sanction, but what kind of sanction? It was, from the beginning, accepted that the ordinary sanction couldn't be imposed on them. That is, the sanction established in the criminal law. What is the sanction established in the criminal law? I don't know, 60 years of prison term. That would make peace impossible. It was accepted that it could be a diminished sanction. We used that with a kind of negotiation with Pablo Escobar, and the negotiation with Pablo Escobar said, okay, if you surrender to the Colombian state, you will receive 5 to 8 years in jail. He accepted, he went to jail, and then his jail became his mansion, and it was another story. That's narco story. But it was accepted in Colombia that, okay, you can reduce sanctions, criminal sanction, to something like 5 to 8 years, it's acceptable. So a lot of people thought, okay, 5 to 8 years in jail. But for the fact that was unacceptable. That was unacceptable for several reasons. Because for them, it was a kind of humiliation. They said, okay, we were heroes of the revolution, and now it means that we are criminals that we end in jail. That's not acceptable. Second, that would make impossible for them to transform in a political actor. If we are in jail, how we are going to make politics? And the idea is that we get involved in politics. And third, for them it was very difficult if the leaders went to jail, how to ensure the demobilization of the troops, how to control the process of demobilization if they were in jail. So for them, this alternative of going to jail was unacceptable. But there was a need of a sanction. And then here, another creative solution, I think, was found. And the creative solution was to make a mixture of a restorative justice approach with a classical retributive criminal approach. If you know the classic retributive criminal approach is you commit a crime, you receive a penalty, you go to jail, and that's it. The restorative mechanism is that it has been used a lot in juvenile crimes, is that you commit a crime, you don't go to jail, but you make restorative sanctions in benefit of victims. And if you make this restorative sanction in benefit to victims, and victims, you can try to have a reconciliation, then you avoid jail, but you make this kind of different sanctions. And it has worked quite well in relation to juvenile justice. But the issue is it possible with international crime like war crimes? And a creative solution was adopted that established a three-tier system of sanctions. This three-tier system of sanctions is those responsible of heinous crimes that did not contribute in any way to truth or to reparations, they would receive a criminal sanction, a diminished criminal sanction, but a criminal sanction, they would go to jail until 20 years of sanctions. So a tough sanctions for Colombian standards. For American standards, of course not. But for Colombian standards, it's a tough sanction. Then they say, those who, on the contrary, contribute immediately to truth, and by contributing immediately to truth, accepted the responsibility of the crime they have committed, then these persons wouldn't go to jail, wouldn't receive a jail time, but these persons would receive a different sanction, which was called, and it's a complex expression, and this has created a lot of discussion, a restriction of freedom in order to achieve restorative sanction in favor of peace and victims. So what does it mean? And it was ambiguous, and that wasn't one of the problems, but the idea is that they would be controlled, but they wouldn't be in jail, their freedom would be restricted, and they would make programs of reparations in favor of victims, only in favor of the peace process. What kind of reparation? They establish a list. Some could be very tough. For instance, the mining. The FARC has put a lot of mines during the war. So you would be making efforts to demine, in which you put your life in danger. For the fact that was acceptable, because they said, okay, we are not in jail, we can make some politics, we can control the way the mobilization is made, and that's not humiliating because we accept a sanction that is, in a sense, benefiting victims and benefit society, which is what we wanted. And they accepted that. And in the middle was those who accepted responsibility and contributed to truth, but lately. This person would receive an alternative sanction of 5 to 8 years in jail. So we have a 3-tier system. Those who immediately contribute, no jail, but go with a restriction of freedom with restorative sanction. Those who don't contribute, jail until 20 years if they are declared responsible. Those who contribute by lately would receive 5 to 8 years of jail. And that was the mechanism. This mechanism created a kind of structure that, in a sense, and that's the message that I want to synthesize, to summarize, sorry. I'm not going to deal with the issue of constitution and constitutional change and the armed conflict because of limits of time. But what I want to summarize is that that was a way in which the Colombian society tried to combine the search of justice with and the realization of rights of the victims with the possibility of achieving peace through a way that strengthened democracy and the rule of law. Because this way we accepted that these crimes were unacceptable, either made by the government, the protection of democratic institutions couldn't be made through atrocious crimes like extrajudicial killings, or even made by the guerrilla. The idea of making a revolution didn't allow to use ways of making war against humanitarian law like massive kidnappings. And I think that this is a mechanism, I cannot go into the details, that a mechanism that can find a possible equilibrium between the search for justice and the search for peace. And that's why I think it's interesting in comparative terms. I cannot enter, because of limits of time, in the issue of constitution and armed conflict. Maybe if you have questions, I can make some comments on that. But I wanted to finish with the discussion in which we are now. In spite of having this good arrangement, or I find it a good arrangement, I have some controversies with the arrangement. I was quite involved in some of the discussion, but I was not responsible for the details in the designing, and I have a lot of controversies with many aspects of the details. I think that the Colombian peace agreement with the FARC shows that there is a possibility of trying to achieve peace with dignity with the victims. As long as you take seriously the idea that you have to take seriously all the rights of the victims, not only to establish criminal responsibility, but of the rights, truth, reparations, guarantees of non-recurrence, and the idea that you can achieve a way in which persons recognize the responsibility, but making it possible for them to assume this responsibility with dignity, because that's crucial if you want to achieve a peace settlement. You cannot achieve a peace settlement by humiliating your enemy, saying, okay, you are going to achieve this peace settlement, but you are going to be humiliated. That makes peace impossible. And this arrangement, by combining a mechanism of restorative justice with retributive justice within the framework of rule of law, I think that it's a good mechanism, and that's why I have defended it, even against some friends in the human rights community that thought that these sanctions were too low. At the end of the day, the ICC, the prosecutor of the ICC, has accepted this structure as long as it is seriously implemented. She has said if the sanctions, this kind of restorative sanctions, are made seriously, that is not a joke, but are made seriously, we can accept that it can meet the standards of international criminal law and international human rights standards. But now that's the discussion in which we are in Colombia. The discussion in which we are in Colombia is that some people do not agree with this kind of sanction and do not agree especially with the special mechanism that was created, the so-called special jurisdiction of peace, because they said, and that's the critics of the peace accord, they said that is a jurisdiction created in favor of the FARC. I don't think so. It's a jurisdiction created in favor of achieving a justice with a peace with a reasonable degree of justice. You cannot achieve peace if you aspire to have the ordinary criminal justice. That makes impossible peace. And you cannot achieve a peace with dignity if you forget the victims. But you can have middle ways in which you can achieve justice with peace with justice. And I think that the peace accord with the FARC is one of the ways, is not the only, is one of the ways of achieving this equilibrium. Thank you very much.